Global happenings today. We communicate. We analyze global news.
Hello beautiful people, welcome back to our channel. A lot of things happened behind the scene that most Nigerians did not know. A lot of persons have been calling out Justice Omotosho over the fact that he has an antecedent of being quite very loyal to wike, but that may not be totally true, as information reaching us shows the fact that but just maybe this particular judiciary or this particular one that is sitting for Mazi Kanu truly wants fair hearing. And don't also forget that Mazi Kanu has been given that opportunity to open and defend himself. Of course, if you follow our playlist, you get to remember also that Mazi Kanu some few hours ago did mention that due to so many exigencies of not having to see through his case file to know exactly where they are per time, to be on speed with the situation, he could not be defending. He can't be defending himself for today, or that's for that yesterday. But he's hopeful that his case file will get to him. He will study, then he will start. He will come up with speed. Well, let's quickly find out what it is that Justice Omotosho did for Mazi Kanu that is making people react. Well, some few hours ago, Justice James Omotosho of the Federal High Court has urged the detained leader of the indigenous people of Biafra, IPOB, Mazi Kanu, to open his defense, dismissing his claims that the Department of State Services, DSS, secretly recorded his conversations with his lawyers. Now, delivering his remarks, Justice Omotosho recalled that in the spirit of fair hearing, he vacated his courtroom on Wednesday from 9 o'clock a.m., which is in the morning, to 2 o'clock p.m., which is at noon time, to allow Mazi Kanu and his legal team to hold a private consultation session. He said that this gesture was made despite the absence of any evidence to support Kanu's allegation that the DSS was eavesdropping on his discussions while in detention. Now, in the spirit of fair hearing, I vacated this courtroom to enable the defendant and his lawyers to have a private consultation, even though there was no proof of any recording by the DSS, Justice Omotosho stated. Now, the judge noted that all the issues Kanu raised in his Thursday submission had already been addressed in the court's earlier ruling on September 26th, when it dismissed his no-case submission. He reminded Kanu that the court had ruled he had a case to answer, thereby granting him the constitutional opportunity to present his defense. On September 26, 2025, I considered those issues and held that he has a case to answer. The judge said this was to enable him exercise his right to fair hearing to make his case. Justice Omotosho emphasized that although the issues raised by the defendant had been previously determined, Kanu was not foreclosed from raising them again in his final written address. He then called on him to begin his defense rather than continue objecting to the court's jurisdiction. I call upon and appeal to the defendant to open his defense. The judge said, I beg the defendant, in the name of the Almighty God, to comport himself and conduct his defense. This is the opportunity that the Constitution gives him under Section 36. It is a right that he can exercise or waive, either expressly or by conduct. The court subsequently adjourned for continuation of the proceedings as Kanu maintained his objection to the court's jurisdiction. And of course, he has also mentioned the fact that his fake case file has not been given him for him to understudy. And don't also forget that some few days ago, I think 2-3 days back, Mazi Kanu had, for whatever reasons, his legal team withdrew. Some persons said, some insider information said it was because the funding to pay the legal team was no longer forthcoming. Those IPOB in diaspora no longer paying. While others said that that's not true, it was a case of Mazi Kanu feel that his defense lawyers are not doing enough. They're not doing enough to release him, being that they are kind of tactically scared of mentioning names, of which he is not scared. My colleague is in the house. What's your take on the fact that Mazi Kanu is now defending himself, and Justice Omotosho did give him opportunity to, interact with his legal team, and even went as far as saying, "Would you like another form of representation other than yourself?" I said no. He was able to defend himself. What do you make of all of this?
First of all, looking at the situation on ground, most people may not really understand what self-representation means. Now, in law, what it actually means is an individual defending or advocating for themselves in legal proceeding without the assistance of a lawyer. And interestingly, in Nigeria, self-representation is constitutionally protected and legally permissible. That's under Section 36, subsection 6C of the 1999 Constitution as amended. Every person charged with a criminal offense has the right to defend himself in person or by legal practitioner of his own choice. But this provision ensures that individuals are not compelled to hire counsel and can opt to represent themselves in both civil and criminal cases, like the case of Mazi Kanu. And the right extends to all courts, including even the Federal High Court, where serious charges like terrorism or treasons are being tried, just like the case of Mazi Kanu. But however, it's important to note that this right is not absolute. Court may intervene if self-representation undermines the administration of justice, such as in case of possibly mental incompetence. That's why the lawyer was talking about him coordinating himself, or disruptive behaviors. For example, a court can appoint standby counsel to assist or take over if the defendant proves incapable of conducting a coherent defense. It's something you've not done. So for you to take the responsibility of doing it, it's always very difficult. And that's why James Omotosho was suggesting that he should have someone on standby, who will assist him. Now, the key implication of it is, number one, self-represented defendants must navigate complex rules such as those in Evidence Act 2011 or Administration of Criminal Justice Act 2015 in Nigeria. Failure to properly file motions, cross-examine witnesses, or object to inadmissible evidence can lead to unfavorable ruling or waive rights. And, he has demanded about 23 well-known Nigerians. Some of them are even legal luminaries, that they should be made available, compelled to be available for him to, carry out cross-examination and all of that. The big question is, would he be able to do it? And I think that's why they are trying as much as they can to provide legal advice to him not to go that way. And another very negative impact of self-representation is the case of it can impact on trial fairness and outcome. Interestingly, studies and legal analysis indicates that self-represented defendants in criminal trial faces a higher conviction rate, sometimes up to 50% more likely to be convicted or receive harsher sentence due to inexperience. Now, the lawyer have more experience than you are, and interestingly, you may make some statement which at the end of the day will end up nailing you. And I just feel that it's, for me, it's absolutely not too good for someone to seek, especially in a high-profile criminal case where the issue of, terrorism is brought in, the issue of, treason is brought in. It's very unadvisable for someone to defend himself, though I know most of the time the cost of legal services could be so high, and the person may feel cheated, especially when you just walk into the court and they adjourn and you still have to pay those legal charges. And also, while self-representation upholds autonomy and access to justice, it can conflict with the right to a fair trial if the defendants lack capacity. Nigerian courts have ruled that denying self-representation violates fair hearing right, but prolonged delays caused by inexperience could prejudice the prosecution or public interest, it's important for all of these to be taken into consideration. We know there are, better side of it, and I feel that the impact of the cost is impacting on the finances of Mazi Nnamdi Kanu. But even with that, we have to take into consideration the other aspect of it, the lack of empathy, emotional bias, higher risk of adverse outcome, time and resources drain, limited access to resources. Because, being that, you're going to get access to having your files reviewed by yourself, but I tell you, self-represented parties oftentimes may struggle, especially if they are seeking for witnesses to appear for them to ask questions. It may not go well because you may not have the wherewithal, to handle it. So for me, at this point, I feel that the likes of Mazi Nnamdi Kanu, especially this is ongoing trial, it's absolutely not a good one, for him to represent himself, so that he will be able to, at the end of the day, walk away with a fairer judgment. Because, if the James Omotosho realizes that he's not up to date in terms of knowledge of his case, it may go adversely against him. I feel that those who are closer to him should give him required legal advice, so that at the end of the day, he will not compound issues for himself. This is just my personal opinion. I know he has a lot of capacity, but he must also look at the cons of, having to stand in for himself. He doesn't have his party. Personal involvement sometimes can mop up clouded judgment on your behalf. That's, since you are there, you may be emotional in the way you see things, and the law, unfortunately, does not